Hey everyone, I'm Diana.lee.davison, an advocate for the falsely accused and wrongfully convicted. I've been starting a project to create a guidebook for the falsely accused to help them understand the criminal process and how they can assist in their own defense. Today, I want to address something I was asked over email regarding whether or not men can protect themselves from false accusations by advance recording evidence of consent. As they say, an ounce of prevention is worth a pound of cure. But the question is, can you proactively prevent yourself from being wrongfully charged with sexual assault? I need to say upfront that I'm not a lawyer and this is not legal advice, but I called up my friend criminal lawyer Joseph Neuberger to talk about this issue off the record. I'll leave links to my Lighthouse project below, as well as my email for people to send me questions for future videos, and a link to Joseph's Toronto law firm, because he's awesome. So, off the record, Joseph, what can we tell guys who are worried about being falsely accused and what they can or can't do to try and protect themselves against that in terms of recording evidence, either through recorded voice conversations, video evidence, text messages, WhatsApp, any of these other electronic messaging services? What are the pros and cons to those things?
Well, as a lead-in, I think to frame my answer, I would say that given the era that we live in, that the way our society thinks or conceives of intimacy has changed and will continue to change because the law has shifted in a manner that makes it very challenging to deal with allegations of sexual assault around the issue of communicated consent, especially right now when we still see the prevalence of male gender bias alive and well in trial. So I think the conception of how we deal with intimacy between partners is something we have to look at on a larger sense. I would also say, before we get into communications like messaging, that to anybody who engages with a person, that they should be very careful and do it under careful circumstances. And you and I know that, I think the way life really is doesn't always equate with what a court may think is appropriate or is something where there's consent. And so we have to be very careful when alcohol is used and other circumstances surrounding the intimacy. Now, with respect to the actual question, any type of communication, whether it's by email or an app or through text message of advanced consent, is essentially meaningless. So later on, a person is always able to change their mind with respect to consent or to the particular sexual activity. So advanced recorded consent really has very little assistance. There may be some depending upon what communications happen afterward, but the prior advanced consent is of little import in the court system.
Well, I think there's one exception to that, and that would be that if the complainant gave an under oath statement to police or gave a police statement, I guess even not under oath, in which they falsify how the sexual encounter began. So if your evidence in advance would disprove narrative given by the complainant, then it would have a potential rebuttal use, yeah?
Right, so that's why I was saying it depends on, in certain narrow circumstances, what the evidence is. So if the complainant specifically states that they didn't consent, that this was a random circumstance, and in fact the accused has a series of communications with this person discussing intimacy and then what appears to be very clear interests and consent to sexual activity, that would rebut the claim by the complainant. But again, you have to understand all the evidence to see how it's relevant, but it would be relevant to narrative in a case that you mentioned. And so in circumstances, it depends upon what the complainant's story really is about how it initiated or how it unfolded, and so it can be relevant.
And also,
in very narrow circumstances.
Yeah, and I have seen a case where somebody had recorded a very young woman, but they were close in age, teenagers, where he had her on video saying, "Yeah, I consent," and she's laughing, and they still charged him anyway, saying that she was too drunk, and that's what she claimed, was she was too intoxicated. And you brought up intoxication as well, so
right, or frankly, the complainant could say that she was just joking at the time, and you're just goofing around, and so in certain cases, it can be absolutely meaningless. It can be it can be discounted very easily by a complainant, and that's why I talk about the nature of the trials, because there still is there's such a shift now. This evidence can be very quickly discounted, even if it has some relevance.
And even more nefarious, the complainant could try to claim that that was a coerced statement, and that would be an aggravating factor if he was found guilty.
Absolutely. If you have a video of somebody laughing and saying, I consent, that's not exactly a sort of an organic unfolding of a relationship. You may have an exchange of messages and communications between people that sort of show an organic, development of some sort of online flirting, and then leading to talking about sex, and then looking to get together and arranging a day to get together. There may be some sort of very organic way that unfolds, and then again, depending upon the story of the complainant, it can be relevant. But so that people aren't confused, advanced consent does not guarantee anything. And so it has to be at the time, as sexual acts are ongoing, that there's continued communicated consent. That's what everybody has to understand. And then any communications after, so post-sex communication.
Well, before we move to after, actually, I often have called this sex in a box, because the actual act, normally there's no recording of it because nobody's text messaging because they're busy having sex. But it is possible for some guys to think, well, what if I record this thing and then save it for later in case I need it, right? What would can they do that? Because this is obviously a very personal, intimate act. Can you actually record a sexual, interaction with somebody without them knowing about it?
Absolutely. It happens, as long as it's not used or published in any way. So that cannot in any way be put online. It cannot be used for a threat of the person. It has to be kept absolutely private and saved. But I have had certain instances where, in fact, somebody recorded particular acts, and actually it seemed that the complainant in that case had known at the time that the recordings were ongoing, but seemed to have forgotten about it at the time of the allegations. And there's nothing inadmissible about it other than you have to do the typical 276 application. Now we've called it 276, 278, but it would be absolutely admissible. And frankly, if it's a recording at the time and it shows that there's active, ongoing communicated consent, a disclosure of that type of evidence would eliminate a prosecution. But you've got to keep it very, very, very confidential. This is not something to disseminate in any way, shape, or form.
Yeah, and certainly you wouldn't want to threaten the person with telling them, I've got this evidence and I'll use it against you, or anything that would be construed as a threat in some kind of way.
You cannot. Yeah, any type of communication where you intimate at all that you're going to publish or use this in some way against that person is an offense in and of itself. And so that is absolutely something you do not want to do in any type of circumstances.
And I also think that, for guys who are trying to be open with women, it's like, hey, look, because they're trying to be preventative here. I'm going to be recording all this. I'm a little bit concerned that could be an aggravating factor in a woman deciding that she's going to make a complaint, because if they know you have video evidence of them, especially of them engaging in a sexual act, I think that that's actually a possible motive for a woman to transform the thing in hindsight into some kind of, accusation. I just think embarrassment.
Privacy.
Yeah. So
look, I mean, these are private, intimate moments between people. So if somebody surreptitiously records it and then somehow...
Well, I'm talking about not surreptitiously recording. Like, I'm talking about telling her, oh, and by the way, I'm recording this just so you can't falsely accuse me. Like, I think that's an aggravating, thing to say to somebody.
I think that would kill the mood.
Yeah. Well, but no, in part, there are guys who call themselves MGTOW who, want to be upfront and clear about this stuff because they think it's really cool and bold and so on, but I think it could actually put them in further trouble.
I agree, and I think this is why I started off by saying that the way our society thinks about or conceives intimacy has changed, and by introducing that type of defensive and protective measure prior to engaging in any intimate contact with an individual is so artificial and so presumes somebody's going to make an allegation. You can't really have intimacy within those circumstances. It's awful, and so
it's unnatural for sure.
Sorry,
it's unnatural for sure.
Absolutely, and I can see how a person.
But you've used the term You've used the term communicated consent a number of times, and this is a Canadian term which we've been told by the Supreme Court that guys need to seek affirmative consent or communicated consent. But no, I've actually said the term that I have in mind. Affirmative consent is a much deeper concept which can go a lot further than what Canada has at play. Affirmative consent is the idea that you need to, against human nature and human sexual behavior, actually stop every time you progress in a sexual activity and seek affirmative, active, ongoing consent.
Yeah, well, we're not there in Canada, thank God, yet. Communicated consent is by words or by action, and if we move to affirmative consent with the concept that this has to be verbal consent at each stage of an act, we might as well just forget about human relations.
Well, we know from court that guys are asked to explain precisely in court how it is they knew that she was consenting, and most people can't actually describe it or articulate what it was they knew, because you're picking up on body language and subtle signals from the person. So what are we to do about that?
Yeah, I think, when it comes to a trial, an accused has to be carefully prepared how they testify, and as intimate and as private as this is, they will have those discussions with their lawyers to how to properly communicate this during their testimony. But the reality is that you should be able to identify certain actions and happenings during the course of the intimacy that would clearly indicate some type of communicated consent. And so the greater difficulty is sometimes a person, when they're accused, testifying, who's never been in court before, never been in trouble before. It may not be the most articulate individual and is very nervous, will have a considerably hard time trying to get that across. But that's sort of a role where the lawyer will have to come in, and the client will have to trust the lawyer, and they'll have to work it out in a way such that the client can properly communicate. But the bigger issue you raised, which I think is very frightening, is if we move towards this idea of affirmative consent, where I think that's just the breakdown of human relations.
Yeah, well, I have noted in the past that, I, as a female, have listened to other women talking about how when you're interested in somebody and you're giving out signals, I'm totally into you, they get so annoyed when a guy doesn't pick up that signal, and you tell them years later, oh yeah, I was totally into you, and they're like, oh my God, I wish I knew about that. So
yeah, but
if you can't pick up, nobody would doubt that somebody doesn't pick up a signal that somebody's interested in them. So I don't know why it's expected that you would 100% be accurate in picking up signals they are into you.
Right. I mean, look, we're dealing with human dynamics and psychology and emotion, and not everybody is as astute as others at picking up or reading others. So, but we don't forget, in a trial, the Crown at the moment still has the burden of proof, lack of consent beyond reasonable doubt.
We don't forget that, Joseph.
Well, no, I know, but I mean, we still.
But I worry that judges forget it sometimes.
Well, I think that, an accused in a case, especially where there's some fairly compelling evidence from the complainant, has to be able to set forth their defense and make it believable. But that said, I mean, there are ways to deal with that. But, coming back to the issue of post-evidence, I mean, those types of messages may or may not be very helpful. But I think what anyone who's accused or who receives a message sometime after an intimate contact with a partner has to be very careful. So let's say they receive a message saying, I was uncomfortable with what happened last night, or maybe more forthright, what you did was wrong, I was drunk, and you forced yourself on me. That type of communication, an individual who receives it has to be extremely careful in their reply, because that evidence, as you know, in working on a certain case, Diana, and in other cases that we've had together, and frankly cases I've defended, the accused response during that messaging, for whatever reason, seems to be taking on more of significance as an admission and interest against interest than ever before, even though the way somebody articulates could be perceived as trying to be sensitive to the needs of the complainant or their emotions, and yet it can still be seen as some sort of an admission. So everybody has to be very careful about that.
I would suggest to people that if they get confronted with an accusation, they should just say, I'm really freaked out right now. Can I have some time to think about what you've just said to me?
Well, I would go a bit further. I would say I'm really surprised or confused by what you're saying, because I thought we had, quite a wonderful evening, and this is what happened with us. But, I need some time to really, process this. Maybe there's a later time we could talk. But I think there should be a little bit more content there.
Well, the problem we know with text messages specifically are that they're really, any written communications are devoid of emotional expression. So this is why we have emoticons and things like that. But they developed emoticons because it was recognized that text communications don't convey emotions properly.
Correct, but I actually have a separate case now where the client who received a message the next morning literally responded, like, "Are you out of your mind?" and then went on to explain what the night was and saying, "I'm just completely, insulted by what you're writing me." And I have those messages right now, so who knows what the Crown will do with it. But you can express emotion through words, but regardless, you have to, whoever is facing this.
But if you're in shock, though, which is like, so the complainant, when they send this message, and actually I want to make a bigger deal about this, the complainant gets to choose a lot of things. They get to choose if and when they're going to confront you in text prior to going to police, or maybe they've already gone to police and they're trying to gather extra evidence. And also, the complainant gets to submit all of these text messages that they choose to the police, and none of that is vetted. But if the accused wants to use text messages that the complainant hasn't provided, those have to be vetted through special applications in Canada now. Right.
So you know very well that I'm against the vetting and the procedure for text messages after the offense about the subject matter. And there are certain. I just happened to have a case decision in Brampton where there was a recording of a conversation afterward, where the judge specifically stated it's not a record, and I'm allowed to use it, and there was no stage 2 in the analysis. So I have 2 more pending in Newmarket where I have a suspicion that certain messages afterward about the subject matter of the offense, there may be a continuation of some of the decisions now, judges saying it's not a record that has to be vetted.
So let's break that down, just so I know what you're talking about, but other people won't. So let's talk about what it means to be a record.
Okay, so if anything, frankly, a recording, a message, a picture, email, any communications on an application where you have a recording of it, any of that can constitute a record, but it shouldn't be, according to the legislation or previously, about the subject matter of the offense. That should be excluded.
Well, it's a record that has an expectation of privacy is the issue.
Okay, well, let's first deal with it in different sections. So if the communication is about what happened that the person's complaining about, then it's about the subject matter of the offense. The legislation actually says that's to be excluded, but it has been included and interpreted in many ways that those are records and those are things that need to be vetted, and everybody's erring on the side of caution, and there's a lot of divided decisions about those types of communication.
Yeah, it has to go to Supreme Court to get some sort of official guidance.
Yeah, that's really what I'm talking about. So, but regardless, you're still in the sense, you still have to disclose now whatever that is to the Crown, whereas before, so long as the lawyer could make the determination that it was about the subject matter of the offense, you never have to bring the application, you never have to disclose it to the Crown, and you could proceed at trial and just cross-examine on it. I've always disclosed prior to trial just to make sure that there's no concern about the accuracy of the document I'm tendering. That being said, we now have this motion, and then if a judge rules that it is a record, then the complainant has a copy, of course, and they have a lawyer who can make submissions on it. And so there's two-way disclosure here.
I wouldn't say of course. I mean, that's the problem right now, is that there are so many split decisions that we've actually got decisions where somebody can say, okay, well, we need to have a process in place to vet this, but they actually don't force the accused to provide it to the complainant. And there's been some sort of halfway house kind of solutions proposed, especially in Ontario. that the complainant might get standing, but their lawyer has to summarize things for them so they don't actually get it. You're still tipping them off to what you have, and it'll let them know.
The summary, it's all useless, because the minute you're in that second stage and then the lawyer has to seek instructions, in order to seek instructions to make submissions to the court, they have to be able to provide some relevant information to the complaint in order to seek instructions. And so the cat's out of the box. We're done. So as far as I'm concerned, that doesn't help the defendant. That puts them in a very prejudicial situation. So if it's about the subject matter of the offense, as far as I'm concerned, the only way this should go, and the only way the Supreme Court of Canada should rule, is if it's about the subject matter of the offense, it's excluded. Because the argument that's behind Bill C-51 originally was this was simply just codifying and catching up with what technology is today, which is a lie. You and I know that. It was to capture all communications because of Gomeshi.
Right.
But if they have some balls on this, then they should actually just stick to what the legislation is and exclude from this process communications about the subject matter of the offense. But I don't think it's going to go that way. And then this idea of giving a summary and then trying to seek instructions on that, I just think it's already out of the box. The minute you communicate with the complainant anything about the nature of the evidence that the defense has, it's over, as far as I'm concerned. The element of surprise, and what's most important that people have a concern about, is somehow a complainant gets surprised about a communication that they have some right of privacy, which is absolute bullshit, because they should never have a right of privacy in a communication they sent to somebody else about what they're complaining about later. And second, they should know exactly what they had sent previously, and why should we have to advise them about that if there's no issue with respect to the authenticity of the communication?
I made that point in a panel discussion we had a while ago. It's like, well, maybe the complainant forgot about it, but it still doesn't change what was taking place at the time. Like, whether they forgot it, we're just reminding them of what their actual state of mind was, or, like
right,
they should.
There was a separate,
it doesn't matter if they remember the emotions and the feelings, and the evidence of what was actually going on remains the same.
Right, and there was a separate Supreme Court of Canada decision before this was coming out that there's a lesser to virtually no privacy interest in text communications, except now there's this movement about privacy with respect to these types of communications, which is, an absurdity.
Well, where's the privacy of the accused?
Sorry?
Because where's the privacy of the accused when the complainant walks into the police station, and this was a verdict in Ontario from Justice Brees Davies, where she said, if we were to say that they have an expectation of privacy, then we get into the whole thing of whether or not police need a warrant to obtain text messages from the complainant against the accused. Because the accused would also have the privacy rights granted to the complainant. It's like you can't just pick and choose who gets rights.
One would hope.
And well, one would hope that the courts would uphold that, right?
Right. But with these text messages, the way that I see that the police and prosecution are looking at it is, however it's worded, they see this as an admission against interest. And that's when we come back to that area of law. Mm-hmm. And I agree that they should be executing a warrant to obtain that, and should not allow, here's my other pet peeve, complainant comes in with screenshots of the text messages. Well, I send out in my disclosure requests all the time asking for the extraction report from the complainant's cell phone to establish the authenticity and the full ambit of all the communications. And of course they go, well, no, they never seized the phone, they're not doing it, and fuck yourself. That's basically the response I get.
Yeah.
But that underscores the importance of the fact that there's two different types of principles at play here. One for the complainant, which is he or she can just photocopy or snap or take a picture of whatever they want and tender it.
Without having to prove they didn't doctor it.
Right, and except an accused has to really establish the veracity of what they're tendering. And I'm very careful to make sure that whatever I'm putting in properly flows. My client has saved it on the phone, and then I take copies of it, put it on a thumb drive, and I provide that by way of disclosure. And I say, if you want to examine my client's phone, knock yourself out. It's available for forensic examination.
When I've
but that's not
screenshotted,
the same for the complainant.
I mean, most people, there's tons of inane conversation in between the relevant portions, but when I've screenshotted things, I always make sure to show that it's what the starting point was and where it actually finished.
Right, but if you really want to deal with this with privacy and you want to deal with authenticity appropriately, you still have to take all of the communications, inane and all, and then once you have that established, then you black out or excise the inane communications, but then you have a way through that can authenticate it. Because I'm telling you, there are, and you know it, there are many cases where it's doctored.
Yeah.
And they pick and choose what they have. I had a case where the Crown had to had to seek a directed verdict of not guilty during the case because I was able to catch the complainant had doctored a recording. I mean, it's the same thing about recordings.
Yeah.
I mean, how many cases do we have where there's an audio recording of an argument, but it starts with him, screaming at her about something and ends at a certain point, and there's no beginning, there's no end, there's no context to it, but there you go. There's a piece of evidence that implicates the accused without any sort of context to it or confirmation of its authenticity.
In audio recordings, I haven't just dealt with those myself. I've helped you deal with cases with similar things. But I do want to mention that in the UK, they seem to have different habits, and we're common law, so we're similar to the UK in Canada. But in the UK, they've had issues where the complainants have had their cell phones taken by police and all of that information obtained by them, and then they go through it if they do bother. There's like tons of reviews on how they're feeling in this area. But advocates for complainants in the UK have said that it's a violation of their privacy to have their cell phones confiscated or demanded or requested to turn over the original recordings on their phone to the police. This is somehow a violation of complainant rights.
Well, then they don't have to turn it over. Then you can't use the messages. My flip side.
But we don't have that in Canada at all. So, I actually envy the UK in that they've done that at any point.
Right, but at some point there will be an application brought by somebody to say that these are not admissible because there's been no attempt to ensure its authenticity. It's only a snippet of communication.
Isn't authenticity assumed in Canada? I've heard.
Sorry?
I've heard that authenticity of text message screenshots are assumed in Canada. That it's assumed that what you're providing in screenshots is accurate unless there's evidence.
That's not my understanding of the law, no. There are rules when it comes to electronic evidence. It's electronic evidence. Mm-hmm. It's in the Canada Evidence Act. There are rules about electronic evidence.
So if this is important because if guys want to actually preserve their text communications, can they just do it in screenshots, or do they have to do some other technique?
My advice is always the same. Whatever message you get, do not delete it. Save the entire communication on your phone or your electronic device. Save a second copy either on your hard drive or your computer, and then make sure you have at least 1 or 2 copies on a flash drive or thumb drive so you have it available, and preserve the evidence. And in every case when I seek to tender this, I always offer the phone for forensic analysis. Always.
Yeah. So, but originally we were talking about preventative measures, and I don't see any way that post-communications can be used in a preventative way. If somebody's going to accuse you, they're just going to do it, right?
Yeah, I mean, I could see somebody writing afterward, one of the parties, like the male, let's say, writing to the other one next morning and saying, that was fantastic. I really enjoyed our time together. You're such a great person. I enjoyed our conversations. Really loved your perspective on our economy. Some shooting the shit with the person, and then you get communications back that are very pleasant and maybe indicative of that there was a really nice evening.
What about if you blanket? Just text them, hey, that was awesome sex. Don't you agree?
Yeah, I think that's a little too blunt.
This is the thing that I can imagine guys doing though, is and then I think the complainant could then say, this text message is obviously contrived, and I had to answer yes, and they could even claim they were still in the guy's apartment when they were forced to answer the text message, right?
Right. I always say understatement wins the day. So, be a gentleman and, make your communications genuine and about more than just that intimate act. and try and have an organic way about you go about it so that it doesn't seem so stupidly obvious.
Yeah. How about people just get to know each other for longer than 3 months before they have sex? How about that?
You mean start send flowers for at least once a week for 3 months afterwards?
How about like getting a psychological report?
Yeah. I mean, the reality is we're dealing with human relations, and so the ability to try and protect yourself against something like this is very challenging. I think, even though this does happen, there are a vast majority of relationships that are successful and people engage and everything goes on fine. But it is these other circumstances where you and I are representing people or helping people who are in these circumstances and falsely accused, and the starkness of it really distorts what life is like in our society. And in the way the courts deal with it is in such an artificial way, completely out of relation with how we interact as human beings, that it becomes so problematic for us. And so anybody who's concerned about this now, the best advice we can say is to be careful, be reasonable, be smart, and don't do things in circumstances where there's, alcohol and circumstances that I don't want to necessarily mention, but, make sure that...
Where there's alcohol, though, Joseph, people regularly drink all the time. At what point do you decide that alcohol is involved as a factor?
A couple of drinks is one thing, but, nowadays with with the discussion about capacity, and you and I have been reviewing the development of how they're articulating capacity consent, it's becoming frightening. So, the original case law, which is still good law, that an intoxicated consent is still consent, and the cognitive level necessary for consent is a fairly low threshold. Regardless, the courts are now talking about meaningful actions or meaningful steps that are evidence of capacity. So simply making a phone call or walking is not evidence of capacity, yet frankly it would be 2 years ago. Right. Because if somebody's walking, talking, dialing a phone number, putting their fingerprint on the phone to open it up, you have cognitive awareness. And the joke of that is, you and I have been through this in a particular case, that just means the mental process to know what you're doing. And that should be plenty. Mm-hmm. But we can see that the movement with respect to capacity is an ability to appreciate what you're consenting to. Well, you would presume that just by being conscious and thinking about certain things, but we can't crawl into people's heads. And they're going to do to capacity consent what they did to consent now.
I know, it's almost like the careful steps factor of trying to seek consent or confirm consent. It's almost like they expect them to have ESP or something like that.
Yeah, you can't. Well, consent's a subjective thing. Okay, well, I can't read somebody else's mind, but I can tell by their actions or by their words, if you're believed in court. Leaving that aside, capacity. How do I really know that this person does or does not have capacity? They may be walking, talking, making jokes, texting on a phone, and I think they have capacity. And we talk about things, but then when the courts start to cut it down into some incredibly artificial mathematical equation, that's just not reality. And a person may never be able to demonstrate that, like a defendant.
I know.
It may be simple. You and I hear the silly thing about, well, when I'm drunk, I would never do this in the first place. So when I'm drunk, why would I do that anyways? If I did that when I was drunk, I must not have had the capacity to consent. Well, that's not an argument. That's absurdity. Yeah. But guess what? The courts are going to start to grab onto this. I
know. And there's nothing that guys can do to prevent charges being laid. The problem is that as soon as the charge is laid, your legal nightmare begins. And so Correct. Even if you have this evidence that, this question in advance was asking, can I obtain evidence to prevent me from being charged? Well, no, you can't stop yourself from being charged. All you can do is hope that your evidence is sufficient to acquire an acquittal. Huh?
Correct. Yes. And in some instances, there may be some evidence you have, depending upon the circumstances, that your lawyer is able to disclose it to the Crown, and there's a good relationship with the Crown, and the case may be able to be withdrawn. But those are much more the rarity now than ever. And
why is that?
There's some cases where there are some level of communications between the parties, and there's an ongoing relationship such that there's other extrinsic evidence that will, if you have a private investigator, take statements from other people who were present on the evening when they were at the restaurant and other stuff. There are some cases where you can still maybe get a withdrawal. So, But that being said, it's very, very difficult.
Is that the public interest factor? That there's a public interest in proceeding with charges regardless of the merit of the evidence?
Well, yeah, the reasonable prospect of conviction. So, but those are really the rarity. You've got to have some really good evidence.
I think we're in a bizarre state of flux right now where we've got the decisions from Goldfinch where they're saying, I'm sorry for using shorthand, and I'll put links in the video description about that, but where you can't even say that you're friends with benefits and things like that. It's like, and we're being asked, we're trying to answer the question, how do you stop even being charged? When you're looking at cases like that, it's hard not to get distressed in terms of...
Well, it is distressing because what it is, again, is that for some absurd reason, saying that you're in a relationship where we're friends but we have sex, so it's friends with benefits, is somehow calling into question a myth and a stereotype. All it is just talking about what the relationship was. And context, an allegation occurs not in a vacuum. It occurs within a context. And what the courts are trying to do because of these advocate groups is to completely sanitize right down to just the incident in question without thinking about anything else. You're going into a trial with blinders on.
Right.
And the accused is going in with hands tied behind his or her back. And so it's very distressing. I think at some point we may see a turn, but not for a while. And these types of decisions are very difficult to deal with. And judges who, you and I have read decisions where judges read what the Supreme Court of Canada writes, but don't think necessarily the same way the Supreme Court of Canada does. And that's why jury trials are important because, sometimes juries will have a better feel for what the human dynamic is and what's going on than a judge now. But then thanks to our government, our ability to get to a jury has been severely cut back. But anyways, that's for another discussion.
Yeah, it's for another discussion. All right, this is awesome. And this is all off the record, so this is not legal advice either from myself or from Joseph. It's just us hashing out our frustration with the current situation. And
I love that.
And also just, for those people who think that they can preempt being charged with a crime, no, you can't. And it doesn't matter what you record prior, during, or after the sexual encounter. You basically just have to accept the fact that you need to try and vet your partners for craziness prior to sleeping with them. How about that?
I like that.
Yeah.